So you each received a copy of the actual broker protocol, or the protocol for broker recruiting. That's the actual document that the firms collectively signed, and that's in your packet. By the way, next to me, on both sides of me, are our wonderful sponsors. So please, I want to say thank you to all of them. You'll see how they participated in the panels, and all the panels are really great, lively discussions, and I really appreciate their keynote efforts here. So if we can just do a quick round of applause for all of our sponsors, I really, really appreciate it. Literally, we cannot do it without them, so thank you very much. So you all have a copy of the protocol for broker recruiting, and one of the nation's, if I would have, this is my opinion, so it's my firm, I could say it, it's the nation's top attorney for protocol is David Gehn. He's really a smart guy, which you would want in your attorney, but he also has a track record of success. The list of the cases that he's won in this area is enormous, and we could go over it time and again. But his talk is extremely timely. He's got a really good explanation of the whole, I think, the history of it, where it is, and what you need to do. So I'm thrilled that he's here with us today, and I think you're going to find this very informative and very exciting. So David, thank you very much, and David Gehn, everyone.
Thanks. Oh, my pleasure. Something new since the protocol started. I use glasses. I want to start by thanking Tony, all the other sponsors. They were wonderful conversations this morning with the Ameriprise and hearing from Schwab and going up for the panels. Really a lot of insights. I want to thank many of my clients actually attended here today. Appreciate that. And I have to say, I've tried over 100 cases. I've been before judges. I've been before juries. I've visited clients that have been incarcerated. I've negotiated millions of dollars in settlements. And there's one thing I've never done in 25 years of practice, and that's be seen by my wife, who's here today. So I thank her for showing up, and wow, it's the first time I feel stress. So I've been working in the financial services industry for 25 years as an attorney. I've done pre-protocol, I've done protocol, I've done non-protocol, I've done bank channel, independent channel at its infancy, traditional, wirehouse, you name it, we've done it. Protocol, just transition in general. And what I want to say, I'm not going to give a big bio on myself, and quite frankly, there's more than there should be in the packets as well, but I'm a service provider too. My partner Matt Baum's here. He supports me in all that I do. We're service providers just like all of you are, whether you're the custodians that are supporting the businesses of the advisors who support the business of your cherished clients. And I'm up at 6, down at 10:30, working weekends, and I work for you, my clients. And we really, really get active and aggressive and passionate about what we do. So one thing I want to be really, really clear about to all of you, with minimal exception, you could all leave. You're employed at will, with minimal exception, and that would be specific contractual exception. So you hear a lot of discussion, and just remember, first and foremost, if there's any takeaway, you could leave if you want, short of, again, a contract and employment for a term, which is quite rare. I'll ask you to write one thing down more: 100%. 100% is the success level my firm has had this year, and quite frankly, over the last several years, supporting and assisting advisors in their transitions to firms. Quite frankly, we also represent firms too, but you can leave and you can successfully leave. And it shouldn't be that hard. You just have to do it the right way. So, as a predicate, I have to learn how to use this. Are any two transitions identical? The answer is no. At least I got one laugh. There's no advisor in a box, by definition. Yeah, I get calls from advisors. Oh, I'm thinking of leaving, I want to transition. Can you send over a checklist? If any of you sitting here think of your business as a checklist, you're probably at the wrong conference. It's not. It's valuable, extremely valuable. It's what you do. It's how you earn your income, how you support your families, and more significantly, it's how you assist your clients, and you're not indifferent to that. So I can't be indifferent to all of the variables that go into your own personal lives in connection with a transition. It's impossible. You have different books, you have different backgrounds, you have different geographies, you may have different contracts. By definition, you'll have different clients. You have different life experience, you have different methodologies of servicing your clients. All goes into the mix in connection with a transition, protocol or non-protocol. Firms like to talk about, and rightfully so, proprietary information. They do. They spend money, they have software and support and name and branding. There's another side to that V. The other side to that V is human proprietary information. That's you, the individual. And you are not the firm, and you are not owned by the firm. Your humanity and DNA is your own. It's not the firm's. So the test is fundamentally, which proprietary information matters more? Is it the firm's or is it the individual's? That's the test in a transition. And a transition is defined not as moving a license, which we all hope happens, because if you've got problems with your U5 and regulatory issues, then that's a whole separate can of worms. But it's having clients come over. So the real issue that I hear about frequently, perhaps daily, is not necessarily protocol compliance. It's how do I get from A to B? And I ask, what are the 3 most feared letters in the alphabet to a financial advisor? Wish I could speak that slowly. It's what I hear all the time. It's turned into a verb. Am I getting TRO'd? Well, no, you're not getting TRO'd necessarily. A TRO, an injunction action, is probably the most potent and immediate weapon that a firm can unleash in connection with a transition, but it's not an automatic, and quite frankly, there's a high legal standard. And I don't really want to get into legal standards, or A, I'll bore you to tears, and B, it'll unduly prolong this presentation. But one of the fundamental and necessary elements in order to obtain a TRO is irreparable harm. And if we're talking about big firms, really? So if you leave Morgan Stanley or UBS, it's going to be irreparably harmed? Not at all. Who's going to be irreparably harmed? The advisor, if that advisor is precluded from moving the business. It's kind of ironic. There are lots of issues aside from just protocol that have to be considered and discussed. It's a holistic process, kind of like financial advice nowadays is oftentimes, and better, from a holistic perspective. It's not just want to buy this stock or bond or fund or ETF or insurance product. Let's understand your financial picture. Similarly, in connection with a move, protocol or non-protocol, you want to understand contracts. What is the U5 language going to be? What are the circumstances relating to the departure? Do you have a promissory note? Are you giving up deferred comp if you move? But the most essential element, and the reason most move, is client movement. So now let's talk. What was the world like pre-protocol? Hard to remember. We specifically kept the wolf of Wall Street out of this picture because it was extinct in the late 90s. I proudly can state that I helped extinguish the wolf of Wall Street through multiple lawsuits. But what would happen pre-2004? Financial advisors departed on a Friday afternoon. They pre-populated ACATs. They took bounties full of PII, personally identifiable information. Attorneys get calls over the weekend. They'd be filing papers on Monday. The ACATs would be flown over the weekend. Cases ultimately settled. And what was the ultimate result? The attorneys made money. We call it the good old days. But that kind of changed. So what's happened? Well, I think it was Tim Oden earlier today talked about leadership, industry leadership, searching for industry leadership. What happens in 2004? Well, the big firms get together and they draft the protocol. My question, why do you need it at all? Think about it. Fundamentally, what's the protocol about? Client privacy and client choice. What do you even need a specific protocol for? But the powers that be in the leadership said, well, let's come up with a document. Brilliant. But here's a copy. Many who talk about it have never read it, and it's really important, in my mind, to look at the first sentence. The principal goal of the following protocol is to further the client's interests of privacy and freedom of choice in connection with the movement of the registered reps. Principal goal, client interests, privacy, freedom of movement. Now, when most people talk about protocol, and I heard it before, and by the way, it was in Morgan Stanley's press release. No, the protocol was enacted to limit litigation. Well, that's actually not what it says. So the drafters and those who come after it don't believe the principal goal of what was drafted. It's supposed to be client-centric. It's treated like, if you've seen, the Budweiser commercials that used to say, drink responsibly. Well, Budweiser makes money with beer sales. They want you to have keg parties and drink as many cases as you want so they can report good earnings to shareholders. Or when a CEO of a casino disingenuously gets on a commercial and says, don't overextend yourself. Well, the casinos aren't getting bigger and brighter and more grand by people not betting. They want you to gamble. I don't truly believe that the intent was the stated reason for the protocol, client interests of privacy and freedom, but that's the agreement. That's what it says. What else do we know about the protocol? It's voluntary. There's no cost. It's not particularly well drafted. It's not defined. There are no defined terms. It's not even dated. There's no enforcement mechanism. It's voluntary and self-policing. You can't go to FINRA, the SEC, or otherwise and say, well, you violated the protocol. There's no adjudicative body. There's no enforcement. There's nothing. There's no penalties for violations. And by the way, it's limited. It doesn't void a contract if it exists. It just limits it to an ability to solicit if a non-solicit provision is in place. Founding firms: Citigroup, Merrill, UBS. Trivia questions. Anyone know who the fourth firm was? Stevens and Company, August 17th, 2004. After the protocol was enacted, and I've been requested to speak for various broker-dealer clients, actually, to their business development teams to assist them in going out in the field with this new frontier, I kind of coined an acronym to describe what the protocol enables. and I came with neat. So in connection with the transition, to be compliant with the protocol, you want to be extra neat, ergo the double T. What are you allowed to take at maximum on an information basis? Name, email, address, title, telephone number, which was effectively your get-out-of-jail-free card. You take that and you don't have to fear litigation. That's it, and that's a max. You have to leave an identical list with account numbers for the firm. It could be on a napkin. Protocol doesn't say it has to be a spreadsheet. It's in writing. It's just you can take those categories, and you got to leave the same thing with an account number. What are the exceptions? Rating, partnership agreements, and sunset agreements. Now, what's rating? Well, that's a whole nother story. All we know is rating is an exception to the protocol. So what happens in 2004 to 2017-ish? I'll call it a relatively peaceful era. There were random litigations determining the scope and the reach of the protocol. You know, someone leaves the protocol, goes non-protocol to protocol, and then the judges are presented with these agreements. They're like, I don't know what the heck you're talking about. It's not state law, but try to come up with some type of an interpretation. But fundamentally, it worked. What happens in the marketplace, in society, between 2004 and 2017? Well, we have a financial crisis in 08-09 following the tech wreck in about 2000. We have explosive advancement in technology. We have an explosion in identity theft, and all of a sudden we're caring a whole bunch more about PII than we ever cared about beforehand and focused. Regulations going up. The reputations of the historical big firms are going down. The costs of creating an independent firm are going down. The advisors no longer need to be reliant upon the services and platforms provided by the bigger firms. And there's a big movement towards independence. So advisors seeking independence go, wow, yeah, but I'm non-solicit. They get in touch with us, we're like, well, go protocol. So I probably assisted over 100 firms, probably more, joining the protocol. And then I'd get referrals and go, you're the protocol guy. Oh, I heard you're the best in the protocol. Okay. Like, you just have to sign a form. No, I heard you're the best. You can, okay. You could do it yourself. You got to sign a joinder form. So I guess I am really brilliant because I could say sign a form. It's kind of analogous to being an NFL agent where you have to say sign a rookie contract and you just say sign it, don't print it. That's it. And the membership of the protocol exploded from 4 in August of 2004 to, I don't quite frankly know, over 1,500. Many of which were one-time joinders, which enabled firms to depart. So what happened to the founding firms, basically late 2017 into 2018? Oh, that was a Halloween surprise. Ooh, most of us know about Morgan Stanley's completely unexpected exit. Well, UBS joined later. Only one of the original signatories remains. Does anyone remember Morgan Stanley's announcement of its departure from the protocol? It was a memo entitled A New Talent Investment Strategy to deliver added value to clients. Talk about disingenuous. And within, and there was a mention of it before, the gamesmanship and the loopholes, well, that was gamesmanship and loopholes. It wasn't a talent investment by Morgan Stanley into the advisors. It was a talent investment strategy by Morgan Stanley into itself. Because if any advisor would want to leave and take advantage of that investment, they'd have to worry about those funny 3 letters we just looked at getting TRO'd. So And then at the back end, they said, you know, here I have the actually quote of it. The protocol was instituted in 2004 to limit litigation. No, it wasn't. You were a drafter and an original signatory. It was intended to further client choice. Who's playing games or seeking loopholes now? So then what happens? A lot of lawsuits were filed in rather quick succession. And by the way, before I leave this, you could leave in 10 days. By the way, you could leave immediately because there's no enforcement anyway. What's the punishment? Well, you didn't give 10 days, so what? Can't be amended. Who's going to sign it? It's static. Hasn't been changed. Can't be changed. There was a comment in one of the breakouts about, well, if I'm an advisor and I joined a firm coming from protocol, and then it leaves the protocol, don't have a basis for a claim in court. Well, might sound attractive, but the fact of the matter is the protocol hasn't changed since it was drafted and signed in 2004. So if you know you're going protocol, you know that the firm you join can leave. So rules haven't changed. Choice was effectuated by an institution to withdraw. Might have had an adverse impact. Merrill Lynch can leave. They can leave on a day's notice. They can leave on 10 days' notice, as with any other. And you can't rightfully argue you changed the rules. Because Morgan Stanley isn't putting into its agreement, we're bringing you over, we're really excited because you're a member of the protocol, we're a member of the protocol, and we promise we're always going to be a member of the protocol. They're not going to do it. Nor do they have to, nor should they. So you're all on notice. And if you read the agreement, you're further on notice. So what's the reaction? It's a big chill. You may notice a couple of pieces of swag from courtesy of Elenoff Grossman, one of which is a stress ball. Financial advisors freaked out, which I thought was pretty cool looking at this. Plans were changed, felt constrained, climate's uncertain. By the way, one of the thoughts was a thumb drive, but certainly under these circumstances, wouldn't want to do that. So what happens? And by the way, our phones were lit up, and thankfully continue to be. But what do you do? And my practice, how do I go backwards? Oh, I'm sorry. My practice Bible, and as a litigator, I live by this, is the principles espoused in Sun Tzu's The Art of War. And what I say for advisors is if you know your enemy and you know yourself, you need not fear the result of 100 battles. If you know yourself but not the enemy, for every victory gained, you will suffer defeat. And if you know neither the enemy nor yourself, you will succumb in every battle. Know what you're doing, know yourself, know your firm, be prepared. We literally just moved on, assisted a team move. It was actually reported by ADVISORHUB. About a $560 million team, branch manager, 7 advisors, whole office, went through a lot of landmines, no problems. From my perspective as counselor towards clients, I go by Sun Tzu in the transitional protocol regard. Supreme excellence consists of breaking the enemy's resistance without fighting. Our goal is not to be in court winning, although we enjoy doing that too, but to avoid the fight and win without it. I actually joked around with the president of the broker-dealer that team just left last week, and I said, that was really a signature achievement. And I said, from a public perspective, it's making as much noise as a tree falling in the forest with nobody around. Does it make noise? No one really knows about it. other than the team and, quite frankly, satisfied clients. Another principle I go by is victorious warriors win first and then go to war, while defeated warriors go to war first and then seek to win. Prepare. Know what you're doing. Have a game plan. Now, Tim Oden said, and he repeated it, and I wholeheartedly agree. He goes, what is the role of the advisor in the client relationship? Couldn't agree more. Look in the mirror. When I get on the phone with prospects almost routinely, if not almost exclusively, I go, I could take all this body of law, I could talk law as much as you want. It's really not all that exciting usually. You don't necessarily want to hear about it anyway. You want to hear how can I get from A to B and do it the right way. He said, this deep legal doctrine, look in the mirror. What is the role of the advisor in the client relationship? How strong are your relationships? Look in the mirror, be honest with yourself. No firm, no third-party vendor, no attorney, or otherwise has the interpersonal relationships that an advisor has with their clients, or the team has with their clients. So, a fundamental predicate to a move is look in the mirror. If you get past that stage, we go to the next. Let's think about information for a moment. In 2004, Facebook was just born. I think it was called like Face Smash or something like that. You know, the iPhone wasn't born yet. Google was in its infancy. LinkedIn and Twitter, LinkedIn may have been around in its infancy. Twitter not around. Think of the world today. Think of how many of you, and hopefully not during the last 20 minutes or so, have looked at your phone repeatedly today. Gotten emails, texts, looked at the internet, phone calls, everything. Google, quicker than I could type my name, I could get my contact information. It's all there at a fingertip. And we don't need like those hook-up phone modems or faxes anymore. It's really fast information delivery. So, in my mind, the information component of the protocol is practically irrelevant. It's all there in the public. Because remember, you're only allowed to take public information. Name, email, address, telephone, title. You could get it all. You could hook it up almost instantaneously. Some firms seem so panicked that they apparently jumped the shark. If you remember from Happy Days back in the 70s, it's when Fonzie, who previously was considered cool, wore aqua blue swim trunks and a leather jacket to jump a shark in a competition, and pretty much it's an expression for turning ridiculous and going immediately downhill afterwards. Well, certain firms now have social media policies where they want to take dominion and control over social media accounts and social media relationships. That's crazy. It's never happening. It's unenforceable. Quite frankly, it's un-American, and boy, that would be a wonderful FINRA enforcement request if I ever got that on behalf of a client. Well, LinkedIn's got 2 billion, registered users right now, so let's be busy for about an hour or a year doing document review. So, what's the biggest issue? What's the biggest tension that really arises now in the protocol, non-protocol era that we live in? Well, it's the deepest legal issue. It's a solicitation. What constitutes a solicitation? And it's state law specific, and it's too complex for this presentation right now. Fundamentally, we can probably all agree on what a solicitation is. Hey, it's Dave. I left and I joined, Morgan Stanley. Would you like to transfer your account? Well, I think we can all pretty much agree that's a solicitation. But the prohibition on solicitations typically aren't just direct solicitations, they're indirect solicitations. That's the difficult area, because by definition, it's broad and undefined. And what is an indirect solicitation? It's somewhat defined, but it also could be in the eye of the beholder, being a judge, being an arbitration panel, or otherwise. And that's where a lot of the conversation flows, because I've heard all kinds of creative ways to try to condition and prepare and think about and, amalgamate and work out a transition. And I heard some really good advice in one of the breakout sessions, which was just be straight and honorable. It makes it really easy. Go back, look in the mirror. Are your client relationships strong? Have you evaluated your business well enough? The clients will move. But otherwise, you're exposing yourself. And you're not just exposing yourself a little bit, it's existential. So it actually matters a lot. And if it matters a lot, your business means a lot, you should prepare a lot. The corollary being, if you don't, then I guess you don't care too much about your business. I hear about, if I say this, if I kind of talk about that, there's two sides to every coin. There's two sides to every V, minimally, in a litigation, non-complex. And words become a game of telephone. You all remember the game of telephone when you're in elementary school, 15 kids lined up in chairs, and you start at one end and you whisper in the ear of the first kid, Superman, and by the end of the day, it's like it comes out and the last child says peanut butter, and all the 5-year-olds have a belly laugh. Well, might be funny for kindergartners, but the exact same thing happens in the financial services industry. You drop an inference or a notion, and I may be leaving, then the receiving advisor, who's rabid to take over an account, speaks to that client and says, have you spoken to Mr. Gehn? Oh yeah, he solicited me to leave. And then I tell it to the branch manager, and then there's a court filing saying, on such and such a date, I solicited that client to leave. So be very careful. Don't be cute, be confident. I talk about often another movie that kind of go by as The Godfather, and be careful with whom you speak, and be careful with clients that you speak with, because it could turn out they're the next Luca Brasi, and then they're sleeping with the fishes. So what on an overall level do we suggest? Don't gun jump. Let's picture Usain Bolt. Usain Bolt, during his prime, was the biggest, fastest sprinter by far. The only thing that beat Usain Bolt was a false start. So you know what? He became a slow starter, because there's no way a human could beat him. He easily could make up for the difference in the 100 yards. He started slow, and he won every time, other than false starts. Similarly, don't gun jump if there's going to be a move, irrespective of protocol, non-protocol. Don't schedule a client appreciation day before your departure. Don't daydream on a computer about your future firm and include actual numbers and hypothetical illustrations of your goals for both you and the advisors you're going to leave with. Don't print documents, particularly including personally identifiable information. Touching a computer is an electronic fingerprint. It's the easiest way to determine course of action. Don't take personally identifiable information. Don't email before departure. Don't stuff your calendar with meetings the 2 weeks before your departure when you've basically taken the 2 months before that off. Don't create a handwritten list from memory, which supposedly occurred after hours at a time you were employed. All fact patterns I've dealt with. Also, don't poke the bear. You're small, relatively speaking. You're leaving a larger organization. Don't alter phone numbers on a protocol list and submit them to the firm. they'll find out really fast. Don't take more than the protocol list. Firms actually call the police. I've had more than one occasion where I've been out at a meeting or a trial and I'm speaking with local law enforcement that's showing up at clients' offices with certain allegations. Don't stalk clients, particularly elderly, at their homes. Don't write letters that include references to the fact that your former firm included fraudulent charges. They don't react well. Don't write articles or blog posts that are disparaging of your former firm. Don't talk about the press about the departure of your firm and gloat. Don't write letters to clients with just direct solicitations or visit them because, as was described to me once, their office was a 9-iron away. Don't disseminate sexually vulgar and graphic comments about your former sales assistants to her boyfriend after you left. And relationships with office managers, that's not the best tact. Don't meet with a client at a diner and sit at a booth, one booth away from your former branch manager, days after your departure. Don't leave immediately after the firm enters into a new office lease that you've asked for 2 years. Don't shred firm files. Don't email family members. The list goes on and on and on. But the fundamentals come back to your client relationships. And by the way, don't be insecure. Don't think that more so pre-protocol than protocol, and irrespective of protocol, that you can't be found. Because just like you can find your clients, if they care about you as much as you think they do, they can find you. And you'll have a presence out there. You could be Googled. You could be found. So what should you do? Seek counsel. So, with all seriousness, we live in a world of specialization. Business people should take care of business matters. Financial advisors should take care of clients. Attorneys should take care of legal. An ounce of prevention is worth a pound of cure. And when you're talking about your business, before you move, what is it worth? And if it's not worth enough, to speak with counsel and make sure you're doing it well and doing it right, then you're making a high-risk business decision. The one-time cost of transition I often discuss with clients relative to the revenue flow associated with an annuitized and presumptively long-term book, it's not a decimal point entry. Understand your complete picture and go through it with counsel and then feel comfortable to depart, protocol or non-protocol. Thank you.